Test, test, test. Can you hear this? No? There we go.
Morning. Done. I can't wait until the end of this week because after that, all I will have will just be classes. Like all of my other
All right. Good morning. The projector is broken today, so that throws a wrench into my carefully laid plans. How was everyone's weekend? Restful? Are we all feeling better? We're not sick? Half the class was sick, so for those of you with crypto portfolios, I'm sorry. I warned you a few weeks ago. All right, so I thought we would start by answering a few questions a couple questions via email, and I'll also give you a chance to now ask, just to review the material from last week. Let me just recap last week, and I'll address a couple questions along the way. So we said last week that Section 5 is a process, essentially sets in place a process that prefers silence to disclosure until the moment the registration statement is filed. The Section 5 reflects a choice of preferring silence during this quiet period, complete silence during the quiet period, followed by restrictions to some extent on what can be said during the waiting period, in favor of one shot, so to speak, announcement of the issuance when the registration statement is filed. So Section 5, in essence, is a kind of preference for silence over disclosure until the registration statement is filed. And we said that this preference for silence can facilitate a kind of informed trading in some situations, particularly Chris Craft-like situations where you have a publicly traded firm already, such that the quiet period effectively gives insiders an advantage, or informed traders more generally an advantage, until the registration statement is filed. Or in the case of the roadshow, we said that by restricting what can be said to ordinary investors, Section 5 gives roadshow participants a kind of advantage. And we debated whether or not the advantages that Section 5 gave by compelling silence, whether or not those advantages were beneficial to, we might say, to the firm or to those investors who are receiving the information, and what the effect of that silence is on investors' ability to learn about the firm and what it's worth. So if you remember last week what we said particularly about the roadshow, that the benefit of the roadshow is that it confers an informational advantage on roadshow participants. And we said that could be helpful for them if they're going to incur some kind of cost to understand how much the business is actually worth. And we said that the roadshow can be rationalized, the selective disclosure at the roadshow can be rationalized as a kind of cost-benefit trade-off, where it's not so easy always to figure out how much a company is worth. And by going to the roadshow, by knowing you're going to have a little bit of an edge on the market because you're able to interview the CEO and just get a little bit better sense for what the company's worth, the profits that you can expect to make from being at the roadshow may cover some costs that you would incur and thereby make it possible for you as an informed trader to better get the value of the firm right. So the conversation around Section 5 reminded us of the general problem that we face in securities law, which by now should be almost second nature to you. And this is really the tension between informed trading and disclosure, right? So by revealing information to the public, you take away the advantage that informed traders have, whether during the quiet period or at the roadshow. But you also take away the profit that they could obtain from trading on selective information. And as a result, you kill the incentive ex ante up front for those sorts of informed traders to invest in costly information acquisition. And that's really the tension that underlies this entire course. We said that we see in the law a recognition of this tension. In particular, we talked about the WIXI, the well-known seasoned issuer exemption. And we said that really both the seasoned issuer, but particularly the WIXI exemption, reflects a recognition of the fact that informed traders may not need much of a profit opportunity when we're talking about very well-known large companies. And so, by basically killing the quiet period, by allowing these large firms to automatically, in the case of WIXIs, offer their securities for sale, what the WIXI exemption does is essentially transfer from informed traders to noise traders, to the general public, by compelling disclosure earlier on. That is, by eliminating the quiet period for WIXIs. Nod your heads if this is all making sense. Okay. So the exemptions to Section 5 in the case of WIXIs reflect a recognition that it's not always necessary to give informed traders this kind of profit-making opportunity. Now, I don't mean to suggest that that's what the SEC thought when it enacted the WIXI rule, but the economics of the WIXI rule reflect that trade-off. Now, we said that one reason we might not be troubled in the case of WIXIs by the absence of informed trading, one reason we might not be troubled by allowing these firms to automatically issue securities to the public, to have automatic shelf registration. Remember, we said one reason that shouldn't bother us necessarily is because these firms are low risk. If you're talking about a Bank of America, or you're talking about a GE, GE may not be a good example. If you're talking about an Apple, or you're talking about a Microsoft or a Google, the eyes of the world are already on these firms. So the function that the quiet period served, we said the goal of slowing down investment, the goal of preventing retail investors or unsophisticated investors from buying in this Arvida-style rush of excitement over the investment opportunity, we said that's not really necessary when the firm is already under such intense scrutiny. And thus, maybe we're not worried about the preference for disclosure early on. And we're not worried about the kinds of considerations that seem to justify the quiet period. Except that there's one problem, we said at the end of class on Thursday, which is that WIXIs are precisely the kinds of firms that are most tightly correlated with the macroeconomy. Now, one of you asked for clarification on that, so I'll just spend a couple more minutes and sort of reiterate it. Remember that investors don't care. If you remember the chart that we looked at showing IPO performance, investors don't really care about volatility per se. It shouldn't bother you if you're an IPO investor that some years you were making 60% and some years you were making 30 or 0 or minus 10 or 20. Why? Well, because it's like a coin flip. 2017, maybe you did well. 2016, maybe you did poorly. 2015, those are just going to average out. Your gains and losses as an IPO investor, as any investor, will average out. So why do you care if you gain a lot or lose a lot? Why do you care if you're swept up in the Arvida hysteria for some investments, only to find out in other cases you bought Bitcoin when it was $100? In other words, there's no reason why investing quickly, which is what Section 5 is designed to prevent, would systematically lead to losses. It's also not clear that investing slowly would lead to average gains that are higher than your average gains if you invested slowly, quickly. In other words, it's not at all clear that Section 5 changes your expected outcomes from investing. Now that should be clear to you, right? Because intuitively, the same brakes, if you will, that slow down your desire to rush to invest in Arvida are the same braking mechanism that would have kept you from buying Bitcoin when it was trading at $100. In other words, slowing down investment decisions cannot, this is the key point for you to see, cannot lead to higher than expected portfolio gains. It cannot. It's logically impossible. It's logically impossible that taking your time causes you to outperform the market, if you will, intuitively. Or that by taking your time, you'll be the one who finds the great investment opportunities. Does everyone see why that cannot be the case? Nod your heads if you see why that cannot be the case. Does someone want to articulate why it cannot be the case that Section 5 increases your average returns? Why is it that by waiting to invest, it cannot be the case that by waiting you will do better than not waiting? Can someone articulate why waiting to invest should not lead to higher average, cannot lead to higher average portfolio returns than not waiting? Who can articulate a reason? So let me help you out here. So one reason, clearly, is that it cannot be the case that you'll do better by waiting, because the investment opportunities, particularly in the case of Section 5, it's not that new opportunities materialize if you don't trade before the registration date. It's the same investment, right? It's the same investment. Arvida was still Arvida. The whole idea was to slow you down before you went and bought it. But if the better investment opportunities are the ones that are waiting for those who wait, then you can always do a little bit better by waiting just a little less. Do you see that? Because by waiting just a little less, think about our $9 and $11 example, right? Go back to that. So I know the firm's worth 11, and the current price that I can buy at is 10, whatever. There's a lot of noise traders. It's 10.50. Remember that example. Am I better off? Is it possible that I could systematically win by waiting? Well, no, right? Because however long I'm going to wait, say I'm going to wait 3 days before I buy. The price is going to be $10.50 during those 3 days. Go back to that example. Someone else will think, oh, if I buy after waiting 2 days, I can buy at $10.50. What will that do? That will increase the price. So on the third day, when I waited, the price is no longer $10.50. It's now jumped. And likewise, someone else, or me maybe, I'll think, well, hey, why did I wait 2 days? I should have waited 1 day. In other words, waiting cannot possibly, not sure if you see this, waiting cannot possibly lead to outperformance because there's always an incentive to jump the queue. Right? I mean, if everyone knows that the best deals are around for those who wait till day 3, then everyone knows that they've got to be there also on day 2, and everyone knows that they're there on day 1, and thus it's impossible. We call this in finance the principle of no arbitrage. It's impossible that these great deals will just be waiting at the right price for you. That's the key idea. At a great price 3 days in. Sure, Arvida will be around at the end of the quiet period, but not at the price that you could have bought it on day one. Bitcoin is around, but it's not at the price it was 3 years ago. So you should, intuitively doubt the idea that you're going to beat the market or do really well as an investor by waiting at all. In fact, probably the only way you would ever have a shot at getting extraordinary portfolio returns is by not waiting. Do you see this? Nod your heads if you see this. Because your only chance to buy, in the case of the hypothetical of 1050, your only chance to buy at the low price that gives you the profit-making opportunity, that's only there as long as no one else has bought. And as long as no one else has bought means as early as possible. Do you see this? Nod your heads if this is making sense. So Section 5 can't be giving you better investment opportunities as someone who's subject to, who's maybe not at the roadshow, or just your average investor who's waiting for the end of the quiet period. Cannot. Impossible. What could Section 5 do? Well, what Section 5 could do is depress the volatility of the gains and losses that you would make if you were to wait, if you were not to wait until the end of the quiet period. In other words, what Section 5 does is prevent you from investing in Bitcoin, right? It prevents you from investing in Arvida because the price has risen. That's the whole point. It takes away great investment opportunities from you because someone else has got there first. But it also takes away really bad investment opportunities, like Bitcoin. Right? In other words, what securities law, let's just say very generally, tries to do by putting the brakes on investment is just get you to invest less. Just gets you to speculate less. It's an anti-Vegas law, right? It's like anti-gambling. That's securities law. It's not like it cuts out the bad bets. That's impossible. It just keeps you from betting. Are there questions on this point? I want to make sure this is clear. That's what Section 5 does. Questions on this? Let's make sure we're all on the same page. Okay. No? I thought I saw it. No. Okay. So, if the point of Section 5 is to slow down your investment, to keep you from making bets, it follows that any exemption to Section 5 facilitates betting, encourages you to bet. And thus, the WIXI exemption can be understood as simply reallocating investment capital from speculative bets that, like Arvida, that are very likely to be successful and very likely to be complete failures. And it just reallocates you, pushes some proportion of your portfolio, of the aggregate investment portfolio, into very safe bets like Apple, right? Now, we said that for investors who are risk averse, which we all are, all investors are, it might be just, we would think, fine, it might be a good idea to reduce portfolio volatility because we don't like volatility. We don't like swings, right? We don't like not having money when we need it, okay? But remember our conversation from the first couple of weeks of the course, that whether or not we have money when we need it depends on macroeconomic volatility and not the pure volatility of any given investment or even of our stock market portfolio. So for that reason, we might wonder whether the WIXI exemption really makes sense. And one of you questioned via email, how is it that WIXIs are correlated with the macroeconomy? Well, when is Apple likely to be very volatile? In a recession. Well, when is Apple likely to go down? In a recession. When are large cap firms that make up WIXIs, the banks, go down the line, large manufacturers, when are they likely to see major price swings, major price decline? In a recession, or as a recession is beginning, or when is anticipated? That is when there's macroeconomic volatility. Look at the market yesterday. Why did the Dow drop 1,200 points? Well, the sense is, look, the economy's overheated, the Fed is going to be raising rates, that's going to cause a slowdown, and as a result, it's not good, that's going to crimp corporate profits, or maybe there's a story around wage growth, that wages are growing, and as a result, corporate profits are going to shrink. Whatever the story is, it's a story of macroeconomic volatility. And by holding the market as a whole, or by holding large cap companies, which is what the WIXI exemption facilitates, you actually increase your exposure relatively to macroeconomic volatility. You are more likely to do well when the economy is performing nicely, or when expectations are high about the economy's performance, and you're more likely to do poorly when the economy is having a bad day or year. On the other hand, investments in idiosyncratic assets, bets, contrarian bets, bets that are not linked to how the stock market is doing as a whole, are often the kind of investments that Section 5 would slow you down from making. So one question that we ended the class with last week was, should the interpretation of Section 5 should the application of Section 5 incorporate macroeconomic considerations? And that's not the law, right? But it's worth thinking about, especially if you were to be looking at an ambiguous case like on an exam, which brings me to a point I wanted to go over before we dive into new material, which is how you would apply this on an exam. But before I do that, are there any questions about the substantive material we covered last week? Any part of it? Is this crystal clear to everyone? Yes. Alistair, right?
Yeah.
Yes.
I just wanted to clarify. So the WIXI exemption, doesn't that equally enable and encourage you to make bets that are completely correlated against the market by enabling you to take short positions on the newly issued stock?
Yes, so exactly. So Alistair asks, couldn't you just short the economy or short large cap firms? Couldn't you take the opposite view so you would do well in bad times and poorly in good times? That's what would happen if you were short. Remember we talked about shorting. If you had sold, if you had just taken the opposite position on large WIXIs, you would do very well in bad times because you're doing well as the market goes down, and you would do poorly in good times because you do poorly when the market goes up. Sure. But you're still doing well or poorly when the market is going up or down. That is, the volatility of your portfolio, your investments, whether you're long or short WIXIs, is directly linked to your consumption. It might be that you are totally contrarian. So you are really suffering when the economy is growing. But that still means that your investment portfolio, the risks that securities law is designed to address, your investment portfolio is moving with consumption. It might be moving for you in your consumption might be opposite in direction to the macroeconomy, so you don't eat when everyone else does. But it's still moving with macroeconomic risk. Does this make sense? Nod your heads if this is clear. And that's the kind of risk that, as an investor, you don't like. Because it could very well be, you just flip everything around, that your portfolio is doing poorly, in this case, when times are good, but you, having taken a short position, are thus suffering at that time. Now, maybe a variant, Alistair, of what you're asking is, could I be long the macroeconomy in like my labor income? So it could be that I have a job that pays me, that I'm hired in good times, but I've gone short with my investment portfolio. So in this case, things are going in opposite directions, right? So the likelihood that I get fired is higher in a recession. But I'm also a contrarian, betting against the market, and so my portfolio has done really well at that point. So you could form a long-short portfolio where basically you're going short the market, and effectively, because you're working in the economy, you're long on your labor income. You could absolutely do that. You probably would find that you would be losing on average, because it's very hard to offset the losses you would have on your equity portfolio with whatever gains you would get on the labor market. But it's not impossible. For example, if you're a lawyer working at a large law firm, like maybe many of you will be, your labor income has a cyclical component to it. You're more likely to get raises, bonuses in good economic times, and you probably don't have a large investment portfolio. And it's possible because why? Because you have student loans, so you're probably not putting a lot of your capital in the stock market. So it could be, you could imagine, right, a setting where you're really kind of these two are canceling out. So you're getting a bonus when times are good. Your portfolio is dropping, but your portfolio is not very large. And so essentially what you've done is just bought insurance, right? So when times are bad, you might not get that bonus, but your portfolio is doing well. You're perfectly hedged, we would say. Now that's fine. But because you're losing and gaining in both states of the macroeconomy, you just have reduced your overall risk. And one way to think, why this connects to our class, is one way to think of securities law is kind of encouraging you to do just that. Securities law is trying to encourage you to not bet your wealth on investments. That's what the law does. And we say that that only benefits investors if it has this kind of insurance function, similar to Alistair's story, where I am employed, have labor income that's positively linked to the macroeconomy, but I got some negative bet on the market. That's effectively, you can think about that as effectively accomplishing what ideally we would want securities law to do, which is to insure you in bad states of the world. That's a little wrinkle and an advanced point, and if it doesn't seem so clear, don't worry. That won't be on the exam. But for those who are putting the ideas together. Other questions? So let's just review how you would answer an exam question on this. And I just want to make sure this is all crystal clear. There's no confusion. So you get a hypothetical which asks about whether a particular, think of like a Chris Kraft hypothetical, right, or an Arvida hypothetical. There's some announcement that's made, there's some content that's out there, and the question is whether it violates Section 5. That's the question. What would you do? You would start by showing you know what Section 5 is, right? I mean, the question isn't going to ask you, like you're supposed to know that, and there will be a story, right? A hypothetical. You've done law school exams. There'll be a story, right? And you'll have to look at it and say, okay, they said something before the registration statement was filed. Oh, Section 5A or 5. Let's start with 5C. 5C prohibits offers to sell prior to the filing of a registration statement, and so you would write Section 5C prohibits. Okay, so first step is just find the issues, apply the law. Write the statute, apply it to the facts. Okay? Here, there was a communication of the following kind. The question is whether that constitutes an offer to sell. Right? Securities. Now, offer isn't defined in Chris Kraft and Arvida. It's nice to show you know, like at least the names of the cases. The question of what constitutes an offer, was applied in different settings. What we see here, you might say, like Arvida, involves a very clear, which it won't be, right? But you could point out in Arvida there were concrete facts about the offering, like remember the number of square feet in the development. So you might find some facts like that. You might say, look, this case isn't as clear as Arvida, but we see that there are some concrete facts about the opportunity that are disclosed prior to a registration statement being filed. Like Arvida, in Arvida, this seemed to tip the court in favor of finding that the communication constituted an offer. And here, it doesn't quite reach the level of Arvida. Probably is likely to be the case, right? And so it's not clear, right? So it could, but it may not. And how would we? Then you would say something like, how would we decide? How should a policymaker decide or a court decide when faced with ambiguous facts? Well, you might look to the goals of Section 5. I'm not saying you need to write all this in prose. It can be quick, right? And so what are the goals of Section 5? Well, Section 5 is trying to strike a balance between informed trading and disclosure. The quiet period effectuates a period of silence whereby certain advantages are conferred to those who have access to information. Now you'd have to think, right, whether it's a 34 Act reporting company, in which case you could trade on the basis of information. You might identify there's a relevant actor who could trade on the basis of it, or if it's an IPO, like Arvida was, you might talk about the roadshow. If the roadshow's in the facts and you need to move on to 5A1, okay, I'm just kind of giving you the roadmap. What you're trying to identify is the tension between giving certain individuals access to information and the really good answer will try to pin down how it is that a strict reading of Section 5 actually does what the securities laws say they're supposed to do, which is protect investors. So a really good answer, right, would say not just that by disclosing information earlier, by taking a very liberal view of the quiet period by allowing the firm to disclose earlier, that would get information out there, but maybe investors won't fully understand it without the entire prospectus, and that could reduce mistakes. But you wouldn't just want to talk about the potential to reduce mistakes, right? Because we said that reducing mistakes may not actually help investors. It may not improve investor welfare. So what you'd want to do is you'd want to say, look, by taking a liberal view of the quiet period, by allowing this information to come out earlier, it might facilitate mistakes. That should concern us, but not if those mistakes are uncorrelated with macroeconomic consumption. And you'd want to try to find something about the fact pattern that shows whether or not the mistakes that would be made as to that firm would likely to be linked to macroeconomic volatility, right? And so just to give an example, imagine you had a coin, right, or a currency, digital currency. And the question is, the debate you'd be trying to really grapple with, and the answer is, do we want disclosure out early, in which case people might jump on the opportunity. That maybe would kill informed trading profits, which is good, but bad, they might get it wrong. But maybe not so bad if it turns out that trading in crypto is not going to be sort of cyclical with the economy. Now, maybe trading in crypto is cyclical with the economy. And so that might be one reason why we would want a stricter quiet period. Okay, so the best answer will show that you understand the material we're talking about, but that you're also able to apply it insightfully to the facts that you're given. Does this make sense? So what will not be as impressive, right, is if you just generically say something like, it's important to reduce risk that investors face. That tells me you don't really understand what kind of risks matter, right? Or if you say, generically, it's important to reduce macroeconomic volatility. That shows me you don't really, you just are regurgitating what we said in class. What you want to do is try to characterize the particular investment opportunity at issue, identify the risks that it actually poses to investors, those facts, and then articulate whether or not those risks are the kind that investors, these investors, and that in the fact pattern, would be better off not having. And that means you have to think about the volatility of those investors' consumption. When is it that they're likely to be eating and not eating, and how this investment would contribute to that or be linked to that. Okay, does this make sense? I want to make sure that it's clear. The best answers, you don't just talk in general about the theory. You don't write a little essay about whether you think this is right or wrong, or you apply it to the facts to show that you really understand what investor protection is. That's what this is, the whole point of this, right? It's to help you see that investors are only better off under very certain conditions. And whether or not we interpret the law in one way or the other, or whether we should, the hypo might even have you as an SEC policymaker making a new rule, right? Whether or not you want the rule to apply to a particular setting should depend on whether it actually helps investors or not. Okay, any questions on how you would approach a question like this? Is this clear? Okay? So we're not going to do generic policy essays, right? You're going to be thinking about how you can apply the law to a problem in a way that shows you really understand what investor protection is. Okay? Okay. All right. So now we're going to move out of Section 5, finally. And it's too bad we don't have a projector, but I hope all of you have computers or tablets or something, and you can at least, or you printed the statutory supplement. That works too. If you have the statutory supplement, you bought it, or you printed out the 34 Act, the 33 Act. What I want to do for the rest of class today is take a little bit of time and just walk through some important documents that you need to know. And you saw this in the reading. We're going to go through the actual documents that you file as a securities lawyer. And this is important because we're going to move in the next couple weeks, this week and next week at least, to a discussion of what exactly companies have to disclose when they are allowed to speak or compelled to speak. So the kinds of situations that we're going to look at are going to range from the registration statement, what you must say in the registration statement when you're finally allowed to say it, all the way to ongoing disclosure under the 34 Act, which we're now going to look at a little bit more systematically. The goal is to understand what is the standard. And you read about materiality. Materiality is a big part of it. What is materiality? But what is generally the standard for whether a particular fact must be disclosed to investors? This is really the sort of heart and soul of securities law, particularly of securities litigation. So to begin, I thought what we do, for those of you who have the statutory supplement or you have a computer, let's just open, well, you might not even have, do you have Form S1 in the statutory supplement? Is the form itself reprinted? Great. So let's just look at Form S1. If you don't have the statutory supplement, you can just Google it. I was hoping to put it up on the screen, but plans got foiled. So if you open Form S1, nod your heads if you have Form S1 in front of you. What is Form S1? Form S1 is the registration statement that you file on the filing date. Remember Section 5? Okay. So Form S1, let's look. This is the blank Form S1, because you're confused. Each firm files a Form S1, but it's with their info. I'm talking now about the blank Form S1. Okay? So let's look at page 4 of Form S1 under the heading Part 1, Information Required in Prospectus. So of course, Form S1, you put your biographical information of your new IPO. There's a bunch of technical, you need to put your employer identification number, you figure out your registration fees, okay, that's all administrative stuff. Let's go to page 4. So page 4 of the PDF, I'm looking at the SEC's PDF for those who have different. Part 1, Information Required in Prospectus. Now, you'll see that the way that the Form S1 is organized is by item numbers. So you have an item 1, for part of registration statement and outside front cover page of prospectus. 2, inside front and outside back cover pages of prospectus. Item 3, summary information, risk factors, and ratio of earnings to fixed charges. Item 4, use of proceeds. Item 5, determination of offering price. Item 6, okay? So the job of a securities lawyer typically involves going through long checklists of items, right? That's what you'll do. You won't be doing a lot of informed trading theory, but you will need to understand what's going on here, right? So we're gonna look at each of these items, not each of them, but we're just gonna look at a couple of them. And what you see immediately is that there's always this sort of standard line, right? Furnish the information required by item something 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 of regulation SK. Nod your heads if you see that. All right. So this is a common structure that we see in the nuts and bolts of securities practice, which is that the SEC produces these forms, and there's always a reference to some regulation, not always. In this case, there's a reference to some regulation that defines the actual content that has to be included. The reason why they do this is, of course, there's a form S3 that we learned about last week, which you can look at if you want, and it's going to say the same thing. It's going to say particular portions, just by reference, go look at Reg SK, Regulation SK, item so-and-so for the content of this section. So let's do that. Let's look at Regulation SK. What should we look at in Regulation SK? Well, how about we look at item 101 of Regulation SK. Now that's, for those of you who would like to Google it, or you just want to know how to find these regs in Westlaw, that is 17 CFR, Chapter 17 of the Code of Federal Regulations, Section 229, Part 229, is Reg SK. So 17 CFR, see if I can do this by Googling it, 229.101. 17 CFR 229.101. That is item 101. And you actually can tell, even if you're just looking at the S1, item 220, it's a section 229.503 of this chapter. So all these forms are actually all in part 229, chapter 229 of Title 17. So let's look, you can just Google it, and Cornell's cool LII thing will come up. 17 CFR 229.101, item 101, description of business. So what does it say? Well, description of business is actually item 11 on the S1. Furnish information required by item 101. What is item 101? It says, describe the general development of the business of the registrant, its subsidiaries, and any predecessors during the past 5 years, or such shorter period as the registrant may have been engaged in business. Information shall be disclosed for earlier periods if material to an understanding of the general development of the business. We'll come back to that sentence in a minute. Let's look at subpart 1. In describing developments, information shall be given as to matters such as the following: the year in which the registrant was organized, its form of organization, the nature and results of any bankruptcy, receivership, or similar proceedings, the nature and result of any other material reclassification, merger, or consolidation, the acquisition or disposition of any material amount of assets otherwise than in the ordinary course of business, and any material changes in the mode of conducting the business. So this is a checklist, right, that when you're in practice, you will, and if you're doing a securities offering, you will just check each of these, right? You will make sure that you have gone through the company's documents and that you have written a paragraph, or however many paragraphs if needed, on each of these points. There's a long checklist, and there's a lot of these. And we're not going to spend this class going through, because we would literally spend the rest of the semester going through each of these items, and that's something that you can do. But what I want to help you see is and understand the case law around what it means to have a material qualifier on one of these items. So if you look at subpart 1, it says the acquisition, as I said, I'll just reread this, the acquisition or disposition of any material amount of assets otherwise than in the ordinary course of business, and any material changes in the mode of conducting the business. So we see this term material come up in Reg SK. You'll see it all over the place. And tomorrow, we're really going to dive into Texas Gulf sulfur. You saw this in the reading. I hope you read it closely. But before we sort of get into what is materiality, let's make sure we've covered a few basic points. The first point is that there is no general duty to disclose on Form S1 or any form all material information. This should be clear. Whatever the definition of materiality is, the fact that Item 101 lists 20 things that have to be disclosed implies that you don't just tell investors everything that you think is material or they think is material. And when we learn the definition of materiality related to something like something they would want to know if they were making an investment decision, something like that, like there's no general duty to disclose on a Form S1 or any securities law filing all material information. That is not the law. Now, if you read Franchard, you might wonder, because some of the language in Franchard kind of leaves you, we'll get to Franchard, but the law formally is that you must disclose what the SEC has compelled you to disclose. This is statutorily authorized, and that's the disclosure duty. So, materiality, we'll unpack it really tomorrow. But whatever materiality is, it is a qualifier on what you must affirmatively disclose under the regs. In other words, it limits the scope of disclosure. Okay? So you see here, right? You've, as a company filing for an IPO, have acquired and disposed of all kinds of assets. You're only required to disclose what? The acquisition or disposition of material assets that did not occur in the ordinary course of business. So there's two requirements. Material assets, not in the course of business. Now, this is important because I'm not going to expect you to know the entire, like all of Reg SK. You can bring 5 pages into the exam, but I might actually print on the exam, like one of these, and just see if you can carefully apply the statute. And carefully applying the statute, and how many of you have had a statutory class like this, means literally every word counts. Okay? So you just want to read this stuff very carefully and make sure that you get it. When you look at assets, what kind of assets must be disclosed? Well, the acquisition or disposition. So if you didn't acquire or dispose, it doesn't count. Right? Just really, really carefully and slowly, right? It's got to be an acquisition or a disposition of a material amount of assets. So it's not that the assets need to be material. Okay, it's the amount of the assets needs to be material. Okay, just one step at a time, very carefully. The amount of the assets that you disclosed, that were acquired or disposed, has to be material to enter into this subpart 1, and they have to be outside the ordinary course of business. Very systematic. Okay. Now, you see that some parts of Reg SK, like 101A1, are going to give you a very specific list, and you're going to follow the list word by word, just like I did. Other parts of Reg SK are not so limited. So if you look at, where did this go? So subpart C, narrative description of the business. Describe the business done and intended to be done by the registrant and its subsidiaries. focusing upon the registrant's dominant segment or each reportable segment about which financial information is presented in the financial statements. Here's the key. To the extent material to an understanding of the registrant's business taken as a whole, the description of each such segment shall include the information specified in paragraph C1I through C1X of this section. The matter specified in paragraph C1XI through C1XII of this section shall be discussed with respect to the registrant's business in general, where material, the segments to which the matters are significant shall be identified. All right? We all okay? So what's the difference here? Well, here, particularly with this qualifier, to the extent material to an understanding of the registrant's business taken as a whole, what you're seeing is that the rule wants you to talk about more than just the acquisition, disposition, whether the amount was. The rule kind of wants you to give investors the whole story, but only about this particular point. What's the point? The segment, right? So you're required to give a description of each, what? Reportable segment about which financial information is presented in the financial statement. Lest you think this is the job of the accountant, this is your job. Now you all want to be securities lawyers, right? This is your job, right? Because the accountant has prepared the financial statements. They've decided, following general accepted accounting principles, which segments are reportable as segments. Now you have those list of segments, and you have to write a description, or you get a description from the business side, and you need to make sure that the description of each segment contains the information listed in subparts I through X, so long as what you're including is material to an understanding of the registrant's business taken as a whole. Does everyone see how this works? Are there questions? This materiality qualifier is broader than the materiality qualifier in subpart A, right? Because this materiality qualifier really goes beyond one point, like the amount of assets that you've acquired or disposed, and covers basically anything that you would need to know as an investor about the registrant's business. Now, lest you think that this is just like, technical gobbledygook, it's actually really important, right? A violation of any of these disclosure standards gives rise to liability. We're going to talk about that in a few weeks. But it also really matters, like if you're advising a company that's saying, okay, what do we need to tell investors? Like, you're the one who's in the hot seat as the lawyer. You're the one who has to decide whether information about an upcoming product, that may be very sensitive and confidential internally, but whether that actually qualifies as a matter that's subject to disclosure, mandatory disclosure. And look at like subpart I of C1, you have to include for each segment the principal products produced and services rendered by the registrant and the segment and the principal markets for and methods of distribution of the segment's principal products or services. In addition, you have to state the amount of percentage of total revenue contributed by any class of similar products, which accounted for 10% or more of a consolidated revenue. Okay. So some of the financial stuff your accountants will do. But what is a principal product? And so these are judgments that you're going to make. And again, not to just talk constantly about the exam, but I want to give you a sense for how you would be working with this material in this class. You might get a registration statement or part of a registration statement with some disclosure. And your job would be to evaluate whether that disclosure complies with something here. Now, I wouldn't expect you to know all of this, but I might give you an excerpt of Reg SK, and your job would be to ask, well, look, was a material fact omitted? How would you answer that question? Well, we're going to dive into what materiality means, but the starting point is what the statute and the regulations promulgated thereunder have to say about the issue. So first the law, then the policy. All right? Everyone with me so far? Okay, now let's look at a few more statutes. So Reg SK is a general rule of qualitative disclosure. That is, it applies whenever there is a requirement to disclose qualitative information about the firm and its business. Form S1 happens to be one of those cases, but there are other cases, right? So if you look, you have the statutory supplement, let's just look at Form 8K. You can Google it, comes right up. Form 8K. Current report pursuant to Section 13 or 15D of the Securities Exchange Act of 1934. What is Form 8K? Well, and we're going to go through here now the 34 Act because we haven't done the 34 Act. We're not going to do an entire section of the class on the 34 Act, but it's important to understand some of the key components of the 34 Act. One of them is Form 8K. So Form 8K is used by companies who are subject to the 34 Act to give investors ongoing information about their products and services, about their business. And in particular, just like Form S1, there is no general rule under the 34 Act of ongoing material disclosure. You are not required to tell your investors, if you're a publicly traded firm, any and everything that might be material. All material events that happened at your firm. No, that is not the law. Instead, as you see, if you look at the general instructions, Form 8K shall be used for current reports under Section 13 or 15D, we'll look at these in just a minute, of the Securities Exchange Act of 1934, filed pursuant to Rule 13A11 or 15D11, we'll look at those, and for reports of non-public information under FD. We won't worry about that too much right now. But then if you, so there's rules that require you to disclose this information, but then if you go down to information to be included in the report, which is on page 4 of the PDF, it's now saying exactly what must be included in a Form 8K. Item 101, entry into a material definite agreement. If the registrant is the firm who's reporting under the 1934 Act, you all see this, item 101. If the registrant has entered into a material definite agreement not made in the ordinary course of business of the registrant, or into any amendment of such agreement that is material to the registrant, you must disclose the following information: the date on which the agreement was entered into, the identity of the parties, description. For purposes of this item 101, a material definitive agreement means, what does it mean? Okay, those of you who've done contract drafting, this is familiar, right? You're defining a term. An agreement that provides for obligations that are material to and enforceable against the registrant, or rights that are material to the registrant and enforceable by the registrant against one or more other parties of the agreement, in each case whether or not subject to conditions. Instructions. Okay, so let's just unpack this, right? So in order for an agreement to be disclosed under this item 101, it must be what? A material definitive agreement. A material definitive agreement means an agreement that provides for obligations that are material to or enforceable against the registrant, or rights that are material to the registrant. So you've got to have material obligations or material rights. And what's the other requirement for it to be for a material definitive agreement to be disclosed under 101? What else has to be true? Not made, thank you, Magdalena, not made in the ordinary course of business. Okay? Well, lo and behold, instruction 1 tells us what it means to be made in the ordinary course of business. An agreement is, second sentence, an agreement is deemed to not be not made in the ordinary course of a registrant's business. Well, actually it doesn't. Even if the agreement is such as ordinarily accompanies the kind of business conducted by the registrant, if it involves the subject matter identified where? You gotta love this, right? Here we go. Item 601B102A of Reg SK. All right, so let's go over. This might seem tedious, but this is like what you're going to do in practice, right? Like this is it. This is day 1 at Cravath. This is what you do, okay? So now we go to 17 CFR 229-601. So you can either look up item 601, you can just copy and paste the CFR reference. Let's just do that and look quickly at it. I'm just going to Google 17 CFR 229.601, or you have it in the statutory supplement if you have Reg SK. And I'm going to see exhibits. I'm going to go to subpart B. They even have a cool little chart in here. Description of exhibits. I'm going to go to sub 10, material contracts. Here we go. B10.2. If the contract is such as ordinarily accompanies the kind of business conducted by the registrant and its subsidiaries, it will be deemed to have been made in the ordinary course of business and need not be filed unless it falls within one or more of the following categories. In which case it shall be filed except where immaterial in amount or significance. Any contract to which, so A gives an example, contract to which directors, officers, other important people are named in the registration statement and the report are parties to a contract other than contracts involving only the purchase or sale of current assets at having a terminal market price. So let's just take part A and kind of unpack this, okay? So you start under item 101 with a general rule that any, let's just call it MDA, any material definitive agreement, must be disclosed if it's not made in the ordinary course of business. But then instruction 1 helpfully tells us that it's not any such agreement, any such MDA, has to be material, remember, to be an MDA, material rights or obligations. Any MDA is deemed to be not in the ordinary course of business and thus must be disclosed if it involves a kind of subject matter identified where? Item 601B10.2a, which is what? Any contract to which the directors, officers, so forth, or security holders even, named in the registration statement or underwriters, are parties. So basically any contract that involves an insider at the firm, or someone important in the firm, unless the contract has a market price. Now, what I might do, again, for the exam, just so you know how to study this stuff, I might actually give you a couple of these to study beforehand or let you bring in on your cheat sheet. I'll tell you which ones, because otherwise this is, there's thousands of pages. But you might get a multiple choice question on something like this. Okay, so we talked about multiple choice in the beginning. I think this is the kind of material that's easily tested via multiple choice, and it's really the kind of thing you need to know as a securities lawyer. Like, if you're practicing securities law in any way, even if you're given an assignment over the summer as a summer associate, like, this is what you do. You go step by step by step. Take your fact pattern and just follow the trail. Okay? So this is the kind of thing that it's like eating your vegetables. You have to do it, right? You just have to do it, okay? I mean, I like salads, but you know. Okay, so you have A through D, a set of categories, like conflicted contracts is like A, or conflicted because they involve key members of the firm, unless they involve just a market price, like let's say an option contract, which involves a market price, wouldn't qualify. Okay, so look for a market price, and you cannot disclose it. So you have A through D, acquisition of property, plants, and equipment, for example, in C, so forth. Then there's an exclusion, 601B. Okay, we've done this enough. I just want to make sure you're, nod your heads if this is all clear. Okay? Okay, back to Form AK. Item 102, termination. Item 103, bankruptcy or receivership. Section 201, completion or acquisition or disposition of assets, and so forth, and so on. So there are a set of categories that must be disclosed under Form AK. Now, if you look at page 2 of the PDF under Section B, events to be reported in time for filing of reports, we'll read, here's subpart 1, A report on this form is required to be filed or furnished as applicable. This is under B, events to be reported under general instructions. The first page of the general instructions, events to be reported in time for filing of report, so the second page of the PDF or the first part of the instructions. A report on this form is required to be filed or furnished as applicable. By the way, does anyone know the difference between filed or furnished? Neither do I, but it's old back when you could furnish, and I don't know. It has nothing to do with furniture, in case you're okay. As applicable, upon the occurrence of any one or more of the events specified in the item sections 1 to 6 and 9 of the form, unless otherwise specified, a report is to be filed or furnished with it. All AKs, all securities filings are filed on the SEC's EDGAR website. So nowadays, whatever furnished meant back in the day, today you just file them online. So that's what this is saying. A report is to be filed or furnished when? Within 4 business days after the occurrence of the event. Now this is much more important, okay, than, well, I think a lot more interesting than a lot of the stuff that we've been talking about so far. You actually have 4 business days after the event occurs to file your Form AK. So that's a long time, right? A long time. If you signed a major contract, which is what the Material Definitive Agreement disclosure rule is oriented towards, you have 5 business days, including the day of the signing itself, before you have to file Form AK. So I once wrote a paper on this where my co-author and I looked at insider trading during this window between when the events happen that give rise to Form AK and this deadline. Turns out there's actually a lot of informed trading during this window. And one reason that that's important for this class is think about, again, our tension between informed trading and disclosure. So Form AK strikes a balance where it says you've got to reveal this to the public, but you got 4 days to do it. Should remind you a little bit of the quiet period. It's the same idea, right? There's a period of time during which now it's permissive. We're going to allow you to disclose sooner. We're going to give you the option of remaining silent. And that can allow informed traders to accumulate positions on the basis of this information. And in fact, I wrote a paper that found empirically that they do, which is interesting. The SEC, or I believe maybe even Congress, yeah, the bank, I believe it's Senate Banking, is looking at shortening this window to prevent that kind of informed trading. But you can see that the tension between informed trading and disclosure rears its head again here. Because what would happen if you were to shorten this window, right? Well, you'd be, just like with Section 5, you'd be getting information out sooner, but it might be less accurate or incomplete in some way. If you're rushing to announce that you signed the deal and you're not able to properly kind of characterize the deal, the market may make inaccurate inferences. Investors might get really excited that you signed this contract. And the original intent behind this 4 business day window was to give you time to get it right, to give you time to write this report, this Form AK, in a way that sort of accurately and fairly, in a fair and balanced sense, portrayed the risk in reward of the opportunity of the new information. So again, shortening this window would raise the same kind of challenges that we've talked about in the WCSI Section 5 setting. Right? You should start to see that the same problem just recurs over and over and over again. And so as we dig through these rules, it should kind of start to feel familiar. And it will. And it will. So that's Form AK. So before we, in the last few minutes of class, what I want to do is just kind of show you the 34 Act briefly before we dive into Texas Gulf tomorrow. Why is that important? Well, Texas Gulf actually involves insider trading. If you read the case, you know that Texas Gulf is not an IPO. So we've been talking about IPOs in Section 5 in the 33 Act. I've now jumped over to AKs, which is a reporting requirement under the 34 Act. Texas Gulf involves insider trading under the 34 Act. That is, trading in the stock of a public company that's already publicly traded on information that hasn't been disclosed. We're going to do insider trading, probably after spring break, but insider trading the law of insider trading prohibits what? Trading on the basis of material non-public information. So the case law on materiality that applies to IPOs, to Section 5 even, that is to Reg SK, that's how it gets into the prospectus, right? Reg SK is referred to by Form S1. Form S1 is the form you've got to file under Section 5 to trade in the security, to even make an offer. Okay, remember this? This is all making sense? Section 5, you got to have an offer. That means you got to have a Form S1 filed. S1 refers to Reg SK. SK refers to material, but material itself is defined in case law that applies to the 34 Act. That arose out of litigation under the 34 Act, specifically insider trading, trading on the basis of material non-public information. So while we haven't yet gotten to insider trading, the definition of materiality was litigated in that setting. Does this make sense? Nod your heads if this is clear. I'm going a little fast. I want to make sure we're all together here. Okay? So one more time. Section 5, that's where we started the class. You got to file a registration statement before you can make an offer to sell a security, 5C, right? Registration statement is filed on Form S1. That's mandated by law, by a rule, that this is the form you must file on, and it contains categories of information you must disclose when you file. S1, those categories, those items, points to Reg SK. We just walked through that. Reg SK contains terms like material that are in fact actually defined or litigated, if you will, in disputes arising out of the 34 Act, which we haven't studied systematically. And you can see in Form 8K the exact same reference to materiality. So what we're going to do for the next couple minutes is just look quickly at the 34 Act, understand where Form 8K is coming from, and we'll talk very briefly today and tomorrow about the prohibition on insider trading that gave rise to Texas Gulf. But we're going to study Texas Gulf for the discussion on what is materiality, right? So we're going to unpack Texas Gulf to understand materiality, not to understand the nuances of the 34 Act or insider trading. Are we all on the same page? This is how kind of the law evolved in this area. So let's just look at the 34 Act, which you should have also in your statutory supplement. Securities Exchange Act of 1934. You can ignore all the declarative preambles. Just jump down to Section 12. And if you have the PDF, it helpfully tells you at the top what section you're at. You got to keep scrolling. 6, 7, 8, 9. Here we go. 10A, 10C, 10D. They didn't want to renumber, so all right. Here we go. Section 12. Registration requirements for securities. Everyone see that? It's on the internet, it's page 111 of the PDF. It shall be unlawful for any member, broker, or dealer to effect, 12A. It shall be unlawful for any member, broker, or dealer to effect a transaction in any security other than an exempted security on a national securities exchange unless a registration is effective as to such security for such exchange in accordance with the provisions of the title of this title and the rules and regulations thereunder. So you cannot, if you are what is a member, broker, or dealer, this is like the NASDAQ, the stock exchanges. We're not going to get too into this, but just think of, the New York Stock Exchange. If you're the New York Stock Exchange, you cannot allow trading in a security unless it's been registered under the 33 Act and is subject to the rules of the 34 Act, that is subject to the disclosure requirements of the 34 Act. The 34 Act, in other words, requires you to comply with its terms if you are a security exchange and want to allow trading of a particular security. You cannot trade a security on a securities exchange under 12A unless you are complying with the 34 Act's rules. How can you register a security under the 34 Act? Well, it turns out security may be registered on a national securities exchange by the issuer, filing an application with the exchange. Such will contain a lot of information that's very similar to Form S1. Now, we have just a little bit of time, but can someone tell me the difference? You should see it right away between the requirement to register here under 12B 12A and B, and what's going on in the 33 Act. What's the key difference between the registration requirement here and registration under the 33 Act? Does anyone see it? What are you not doing here that you're doing under the 33 Act? What are you not doing here when you register under the 34 Act that you're doing in the 33 Act? What do you, yes? That'd be right. Even more fundamental. Offering what? Yeah, tell me your name. Catherine.
You're not making a securities offering.
Good. Offering what? To sell, right? You're not selling. The firm is not selling. It's not offering, that's right, but it's also not selling. There's no sale. There's no capital raising transaction. This is purely about registration for trading. Okay? That's it. You want to be traded on a national market, like the New York Stock Exchange. What? So what do you got to do? You got to register under the 34 Act. It is not the same thing as registering your securities under the 33 Act by filing a registration statement. It's not the same thing, but in practice, they end up being effectively the same thing. Yes?
So if I'm selling a security, for example, to everyone in this room, but I have
Yes.
no intention of selling on any exchange, I don't have to register with 34?
That's basically right. That's basically right. I mean, there are, I'm not giving you legal advice. There are, okay? Don't do it. But your intuition is right, right? The 33 Act, Section 5, prohibits offers and sales. You must comply with Section 5 if you're going to offer or sell. Full stop. There are exemptions to Section 5. There are exemptions we didn't talk about. There are intrastate exemptions. One of you asked about intrastate. There's an intrastate exemption. Of course, then you're subject to New York law, has its own set of rules. But in principle, you're right. The 34 Act, 12A, only applies to securities traded on exchanges. If you're familiar with over-the-counter bulletin board, it's called OTC BB or just OTC markets. Those are like what you're thinking, where you don't have a central exchange. Instead, you have sort of negotiated transactions between participants. We'll dive into this. OTC trading is not encompassed by 12A. But if we look down a little bit, on 12G, to go down a little bit further, little g, 1, that's on page 116 of the PDF, every issuer which is engaged in interstate commerce or in a business affecting interstate commerce or whose securities are traded by use of the mails, instrumentality, okay, whatever, shall within 120 days after the last day of its first fiscal year, had total assets exceeding, if the issuer had total assets exceeding $10 million and a class of equity securities held by record, held of record by either 2,000 persons or 500 persons who are not accredited investors, shall what? Register such security by filing with the Commission a registration statement. That's further down. There's a little part about banks. We're out of time, but I don't want to go over. But just so you see the schematic here. Yes, you're right. If you're not traded on an exchange, you don't have to register under the 34 Act unless, under 12G, you have too many shareholders. Those who remember what drove the Facebook IPO was the concern that 12G would be triggered. So 12G is what we're going to talk tomorrow at the beginning of class about the direct listing phenomenon that we see with Spotify. What is going on? That is all about the 34 Act registration. There's no securities being sold. All this conversation around direct listing, what happened with Facebook, this is all a conversation around the need to register under the 34 Act and start disclosing under, for example, Section 13, which we'll end with. If you go down to page 123 of the PDF, you'll see Section 13, periodical and other reports. Every issuer of a security registered pursuant to Section 12 of this title shall file with the Commission such information, subpart 1, as the Commission shall require. In other words, the Form 8K disclosure regime that we looked at is, by the text of Section 13, applicable to those firms that must register under Section 12 or have chosen to do so in order to be traded on an exchange. This is not crucial to the class. It's worth you looking at again tonight. we'll cover it again quickly at the start of next class. It's much more important to understand what is material, because this is pretty mechanical. What is material is not, and involves some very difficult trade-offs and policy considerations. Reread Franchard, reread Texas Gulf in particular, and we'll talk about that tomorrow. All right, thank you. Oh, if you just Google 1934 Act.
Pardon?
We're fucking exhausted.
Yeah.
So you know this last thing, like how this class always gets us, like there's an airplane box, we're going to have a ship oh, when is that? So just now, but like, there's going to be fun of people because they have the same It's okay, I went through it last year.
You're not going to be asked a question like what is sexual lives like.
You're getting lunch?
Yeah. But you're right. There's a practice.
What?
That's so hard.
Are you thinking of getting a food? Oh, okay. Oh yeah, it's Mel's Burger, right? You got it, I didn't skimmed it, but I saw Mel's Burger.
That one.